Hello everyone and welcome back. In this video, I'm going to talk to you about the Marchman Act and specifically the assessment period. Now, the Marchman Act has always had two steps. The first is a period of assessment and the second is the period of treatment. The change, or I should say one of the changes to the Marchman Act, because there was a bunch that were happened in 2024, is that when we file our petition, instead of filing separate petitions, one for assessment and one for treatment, now we file one petition and we make the request for all of the things that we want. And if we don't ask for something, guess what? It's waived. You can't ask for it again. You missed the boat, the train's left the station. You get the picture, right? So it used to be under the old statute that when we filed a petition for assessment, and we typically file these as emergency ex partes, meaning it's filed as an emergency and it's filed without the other person knowing. It used to be that the court order was good for up to 5 days, and then if we filed the second part, the petition for treatment services, within that 5-day window, the facility was legally entitled to hold the person pending further order of the court, meaning until the treatment services hearing occurred, which was typically, within 10 days, unless there was a continuance. Now, under the new statute, the court order for assessment says it's basically good for up to 72 hours, unless, of course, there is a need for things like detox or medical services. So we took that 5-day window and we sort of compressed it into 72 hours, which I think is a huge mistake. I know there are people out there say, well, it was done without due process. But the problem is that if somebody's only held up to 72 hours and then they go and the hearing doesn't take place for another week, who knows what happens to them? They leave. They overdose. I mean, horrible things happen to them. We like to file the case, get them picked up, get the assessment done, have a hearing, and send them off to treatment. No spaces, no gaps. Unfortunately, the legislature has made it a little more difficult for us. But still, I mean, we obviously are dealing with facilities that we can work with, and the idea being that, that the assessment gets done correctly, because in some of these counties it doesn't get done properly. But the big change for 2025 is this compression of the time for assessment, which is why, especially in some of these smaller counties that, in my opinion, are not particularly good at handling Marchman Act cases, I'm a big advocate for filing for a guardianship, because that gives you a whole lot more control than a Marchman Act. And I don't have to rely on a receiving facility that's going to do a lousy job with the assessment. Like I said in another video, some counties are good at this and some are just really bad. And having filed these cases all over the state of Florida, we're pretty switched on to which is good and which is not so good. But I wanted to fill you in and let you know about that big change in the statute from 2024 to 2025. And with that said, thanks for tuning in. See you in the next video. Bye-bye.